Vindictive attitude of wife to drag husband's brothers-in-laws, uncles and aunt under Section 498A, says Bombay High Court Aurangabad bench. Section 498A IPC, which is now referred to as Section 85 and 86 of the BNS, is one of the most draconian criminal law in India. Amidst a matrimonial dispute, a wife is empowered to name every single member of husband's family, even if they would have just met her during the marriage reception. In the current case, parties got married in June 2022, post which the wife moved to her matrimonial home in Pune. In her complaint, the wife alleged that after reaching her husband's home, she learned that he was unemployed. She accused him of subjecting her to physical and mental cruelty, including unnatural sex acts under Section 377 of the IPC. She further claimed that her in-laws did not pay heed to her complaints and pressured her to comply with her husband's demands or seek a divorce. Adding further, she alleged that when she returned to her matrimonial home, she was verbally and physically abused. Her husband would even defame her, calling her a person of third gender. She also accused her in-laws of conspiring to portray her as a mentally unstable woman by misleading doctors into fabricating medical records. The complaint under Section 498A IPC was filed against husband, his parents, husband's brothers-in-laws, uncles, and an aunt. Accordingly, they all approached the High Court to seek relief. The accused, that is the brothers-in-law, the uncles, and the aunt, sought quashing of the FIR on grounds that they lived separately from the complainant and her husband and had no involvement in the alleged offences. The prosecution, however, argued that the complainant suffered abuse at the hands of all her in-laws. Now, what were the observations of the Bombay High Court? The Aurangabad bench of the Bombay High Court has now quashed proceedings against all the accused except the husband and his parents. The High Court ruled that the instigation or common intention alone is insufficient to invoke Section 498A of the Indian Penal Code, and that an individual's independent actions must amount to cruelty for the offence to be established. The division bench of Justice Vibha Kankanwadi and Justice Sanjay Deshmukh held, each person should act in his own way and the said act independently should amount to cruelty. Instigation or common intention cannot be the basis on which the offence under Section 498A of the Indian Penal Code can be proved. The High Court then went on to question the 8-month delay in filing the FIR and noted that there was no mention of whether the wife had informed her parents about the tortures inflicted upon her at that time. Upon reviewing the medical records, the court found no evidence to support claims of coercion or fabrication by the in-laws. The doctor's report indicated that the couple did face marital discord and financial struggles, but did not declare the complainant wife as mentally unstable. The court ultimately ruled that aside from the husband and his parents, the allegations did not meet the legal standard for cruelty under Section 498A of the IPC. The court went on to observe that the complainant appeared to be acting with a vindictive attitude, falsely implicating distant relatives. Quashing the criminal proceedings against the complainant's brothers-in-law, her husband's uncles, and his aunt, the High Court bench noted, it appears that with some ulterior motive, the informant is levelling allegations against the husbands of married sisters-in-law, uncles, and aunt of the husband. It would be unjust to ask these applicants to face trial. Keep following us on our social media handles, that is Instagram, X, Facebook, and Telegram. The ID is @voiceformenin. You can also visit our website voiceformenindia.com to read other articles and stories. If you liked our video today, please consider giving us a like and subscribe to our channel for regular updates. Thank you very much for watching. Namaste. Jai Hind.